Namaskar, sir.
What is your name?
Sir, my name is Durga Prasad Panda.
Explain it a little bit more.
Sir, I did my graduation from the Law College, Kotak, and I'm currently pursuing LLM in Utkal University, and I'm also preparing for judiciary, and this is my first attempt.
You're from Kotak?
Sir, I'm from Jaspur, but I did my graduation in law from the Law College, Kotak.
Okay. So have you gone to Bali Jatra ever?
Yes, sir, I have gone to Bali Jatra.
Enjoyed it?
Yes, sir.
And why Bali Jatra? Like, what is there in Bali Jatra? Why it is so enjoyable?
Because, sir, you get a lot of things in cheaper rates.
Oh, okay.
And
you are a cost-effective person, huh?
Yes, sir.
Tell me something about Bali Jatra.
Sir, I had ki Bali Jatra is in the name of a place Bali, where the Odia people who did this voyage journey to the Bali and did this business or trade there. So that's why it is called Bali Jatra.
Okay, so any person of your family is in this legal background?
Yes, sir.
Or
yes, sir.
who?
Sir, my father is a lawyer.
And yet you decided to come to judiciary?
Sir, my elder father, Badapa, he is also a retired district judge.
Okay. So you have taken your inspiration from your elder father, right?
Yes, sir.
So let's discuss some civil laws.
Yes, sir.
Will it be okay to you?
Yes, sir.
Okay. Can you tell me what do you mean by misjoinder of parties?
When the necessary parties are not joined in the suit, it is misjoinder parties.
And what is non-joinder parties then?
Sorry, sir. When the necessary parties are not joined, it is non-joinder parties.
Okay.
When it does not, the adding of parties does not comply with the rule 1 or rule 3 of order 1, then it is misjoinder. If plaintiff has been wrongly named in place of defendant or something, then it is misjoinder. But not adding of necessary parties, non-joinder.
Okay. Okay. So have you heard this word garnishing?
Yes, sir.
What is it?
So garnish is judgment debtor's debtor.
Explain.
Sir, if suppose the debt cannot be recovered from judgment debtor, then the judgment debtors can be compelled to satisfy the debt, and it can be directed that you should not give the payment to judgment debtor, and it can be made to the court directly.
Okay. So is there any difference between this garnishing order or injunction order?
Yes, sir. Injunction is basically restraining a party to do or not to do something, but garnishee order is compelling a person to not give the debt to the judgment debtor and to pay to the party which is entitled to it.
Okay. So how many kind of injunctions are there?
There are injunctions on the basis of time. It can be of two types, that is perpetual injunction or temporary injunction. And if we go about the nature of injunction, it can be prohibitory injunction or mandatory injunction.
Yeah. So can you explain me a little bit more about mandatory injunction?
Mandatory injunctions are when the court compels a positive performance of from the person. It is mandatory injunction.
Let us now discuss a little bit of criminal law. Okay. So, difference between charge and cognizance.
Cognizance is when the magistrate applies his judicial mind to proceed further on the basis of police report or on the basis of complaint. But charge is framed later. Charge is when actually the trial begins. The formal accusation of the thing is said to the accused. Then these are the charges against you.
So, what are the basis of framing cognizance? What are the materials and things to be seen by a judge to take cognizance of offense?
The magistrate can look into the police report and can take cognizance.
And is there? I mean, and then what is the basis of documents upon which a charge can be found?
In case of charge, the court will also hear the submission of the accused or hear the submission of the prosecutor regarding all the evidence that they have, and if the court believes that there is ground for proceeding, then it will form charge.
Okay. So, whether like in both the situation in cognizance and charge, the offense to be remain same or it can be changed, it can be altered or something.
Yes, sir. In charge, offense can be changed. If
Let's say in a case where being a magistrate, you have taken cognizance of offense under section 307, which is tribal by code of session, right? Can you frame charge of it?
no, sir,
Why?
because the case is exclusively tribal by the court of session. That's why it is to be committed to the court of session.
So the cognizance taking court is not always required to frame charge, right?
Yes, sir.
Let's say there is an offense, okay, for which the punishment is the pecuniary punishment is more than the pecuniary limit of a magistrate, but it is tribal by magistrate.
Yes, sir.
If you don't get it, I'm telling you, under Bihar and Odisha says that let's say the offense, pecuniary offense, fine is mandatorily 20,000. Okay. So whether you can
what is the punishment?
Punishment is 3 or 5 or something. It is extendable upon the nature of the offense, but the pecuniary limit is beyond the limit of the magistrate. So in that case, whether the magistrate can frame charge.
If it is tribal by the magistrate, then magistrate can frame charge.
Have you gone through section 238 of CRPC?
I have gone through, but I do not know the exact provisions right now.
Okay.
Is it about discharge, sir?
So tell me 3 qualities, okay, of a good judge.
The first quality of judge is to be honest. Honesty. Second one is doing the job sincerely. And third one is delivering justice.
What is natural justice then?
Natural justice is based on 2 principles. Odi alterum patum. That is, no one can be condemned unheard. Another is rule against bias. Then there should be fairness.
I'm going to put my last question to you. What is the difference between the statements recorded under section 161 of CRPC and 164 of CRPC?
Sir, 161 CRPC tells about the police officer during the investigation will record the statement of the witnesses. And 164 tells about confessional and other statement recorded by the magistrate.
And what is the difference between the two when it comes to appreciation of evidence?
Sir, 161 statements, they cannot be used as evidence. They are very weaker piece of evidence. They can only be used for the purpose of contradiction. They cannot be used for the purpose of corroboration. But 164 is a substantive piece of evidence. It can be used against the accused or against the person making it.
So thank you.